Real estate lawyer explains easements that destroy property value. Most real estate investors never see it coming. They acquire what appears to be a profitable property, only to discover an easement buried in the title that decimates resale value, blocks development potential, or worse, creates unlimited liability exposure. I'm going to show you exactly which easements can destroy your investment, how to identify them during due diligence, and the strategies sophisticated investors use to either avoid them or turn them to their advantage. The hidden value destroyers. Let me start with the most dangerous easement most investors completely overlook: the utility easement with perpetual access rights and no maintenance limitations. Here's what makes this toxic. When a utility company holds an easement granting reasonable access for maintenance and repair, courts have consistently interpreted this broadly. I've seen cases where utility companies excavated 50 feet beyond the easement boundary, left properties unusable for months, and the owner had zero recourse. The property becomes functionally worthless during these periods, but mortgage payments continue. Insurance may not cover business interruption, and you cannot legally prevent the access. The second category that sophisticated investors screen for aggressively: drainage easements with erosion liability. These appear innocuous in title reports, often just a 20-foot strip designated for water flow. But here's the reality. If that drainage easement fails and water damages neighboring properties, the liability typically flows to the landowner, not the easement holder. I worked on a case where a single storm event created $800,000 in downstream property damage. The commercial property owner was held responsible because they had failed to maintain adequate drainage, even though the easement specifically granted the municipality control over that drainage system. Third, and this is critical for anyone considering development: access easements with ambiguous necessary use language. I've watched investors spend $200,000 on plans for a mixed-use development, only to have an easement holder claim the proposed building would interfere with their necessary access. The court sided with the easement holder. Project canceled. Capital lost. This happens because the easement language said access must remain adequate for all necessary purposes, with no definition of necessary and no limitation on future uses. The due diligence blind spots. Now let's talk about what title insurance doesn't protect you from, because this is where experienced investors separate themselves from amateurs who rely solely on standard title policies. Title insurance typically covers easements that aren't properly recorded. What it doesn't cover is the impact of properly recorded easements on your intended use. Read that again. Your title policy might confirm that yes, there's a recorded easement, but it provides zero protection if that easement makes your development plans impossible. Here's the due diligence protocol sophisticated investors follow. First, obtain the complete chain of easement documents, not just the current summary. Easements are frequently modified, expanded, or have side letters that don't appear in standard title work. I've found critical amendments buried in county records that expanded an easement holder's rights by 300%. Amendments that never appeared in the title commitment. Second, physically walk every easement on the property with a surveyor and an engineer. Not a title company representative. A surveyor and an engineer. They need to identify whether the easement, as described, matches the easement as actually used. Adverse possession applies to easements. If someone has been using 30 feet when the easement grants them 20 feet, and they've done this continuously for the statutory period, they may now legally own that additional 10 feet. Your title insurance won't cover this because it's based on how things should be, not how things actually are. Third, request all maintenance records related to the easement for the past 10 years. If it's a utility easement, get the utility company's access logs. If it's a shared driveway, get the maintenance invoices. This reveals patterns. A utility company that accessed a property twice in 10 years is different from one that accessed it 40 times. One suggests a stable, established system. The other suggests aging infrastructure that will require increasingly frequent and invasive maintenance on your investment timeline. The valuation impact formula. Let me give you the actual numbers on how different easements affect property values, because this is where you make or lose money on the buy decision. Conservation easements on investment property typically reduce value by 30 to 60%. Not the feel-good 10 to 15% that sellers will claim. 30 to 60%. Why? Because you've eliminated the highest and best use options. You can't develop. You can't substantially modify. You can't adapt to market changes. You've converted investment property into a fixed-use asset in a dynamic market. The discount must reflect that permanent flexibility loss. Exclusive access easements favoring a neighboring property reduce value by 15 to 35%, depending on frequency of use and maintenance obligations. Here's what drives that range. If you're obligated to maintain the easement area, add 10 percentage points to the discount. If the easement permits commercial vehicle traffic, add another 5 to 8 percentage points. If there's no specified maximum width, and the neighbor can claim they need to expand it, you're at the top of that range or beyond. Non-exclusive access easements where you share use rights typically impact value by 8 to 20%. The critical variable here is the number of other rights holders and whether they're residential or commercial users. Each additional commercial user adds approximately 3 percentage points to the value reduction because commercial use means more wear, more maintenance costs, and more potential disputes. Offensive strategies for sophisticated investors. Now here's where we shift from defense to offense, because sophisticated investors don't just avoid bad easements. They acquire properties with easement problems at significant discounts and solve them for profit. Strategy 1. Easement extinguishment through changed circumstances. When an easement's original purpose no longer exists, courts can terminate it. I've helped investors acquire landlocked properties with remnant railroad easements at 40-cent dollars, then successfully extinguished those easements because the railroad hadn't operated in 30 years and had been formally abandoned. Property value increased by 200% within 18 months. Strategy 2. Easement subordination agreements. If you're acquiring a property where an easement interferes with financing, approach the easement holder before you close and negotiate subordination. They subordinate their easement to your mortgage lender's lien. This often costs only $5,000 to $15,000 in legal fees, but makes the property financeable at conventional rates instead of hard money rates. The immediate equity gain from financing arbitrage alone can be $150,000 on a $1 million property. Strategy 3. Easement buyouts structured as development partnerships. Instead of trying to eliminate an easement through litigation or negotiation, offer the easement holder an equity position in your development. I structured a deal where a property owner gave a utility company 3% equity in a mixed-use development in exchange for relocating underground lines. The utility company gained more value from the equity than they would have from maintaining the easement position. The developer got clean title, and both parties profited when the project stabilized. The non-negotiable contractual protections. Finally, let's talk about the specific contract language that protects you when you're acquiring property with existing easements. Never, and I mean never, accept standards subject to easements of record language without adding specific representations and warranties. Your purchase agreement must include seller representations that they have received no notice of easement violations, no notice of planned easement expansions, and no knowledge of disputes regarding easement interpretation. These representations survive closing and create a claim path if you discover problems the seller knew about but didn't disclose. Second, require an estoppel certificate from every easement holder of record. Just like you'd get a tenant estoppel in a commercial acquisition, get an easement estoppel. It confirms the easement terms, confirms there are no defaults, confirms there are no planned modifications, and confirms the current access patterns. An easement holder who refuses to provide this certificate is telling you there's a problem. Walk away or discount accordingly. Third, include a specific contingency for easement impact analysis with defined metrics. Your contract should state that if any easement reduces buildable area by more than X%, or increases required setbacks by more than Y feet, or prevents your intended use, you can terminate. Don't rely on general feasibility contingencies. They're too vague and create litigation risk. Specific, measurable easement impact thresholds are enforceable and clear. Easements represent one of the most significant title risks in real estate investment, yet they receive a fraction of the due diligence attention compared to environmental issues or zoning. The sophisticated investor's advantage comes from treating easement analysis as a specialized discipline requiring legal counsel, engineering assessment, and financial modeling, not a checkbox item on a standard title review. When you approach easements with this level of rigor, you either avoid the disasters that destroy less sophisticated investors, or you identify the opportunities they're too afraid to pursue. Both positions generate alpha. If you found this analysis valuable, subscribe to this channel for more sophisticated real estate intelligence that other investors aren't discussing. Hit the like button if this saved you from a potential easement disaster or showed you an opportunity you hadn't considered. And drop a comment below. Tell me about the most problematic easement you've encountered in your investing career, or ask questions about specific easement situations you're evaluating right now. I read every comment, and your real-world scenarios often become future content. Important legal disclaimer: I am not your attorney, and nothing in this presentation creates an attorney-client relationship. This content is for educational and informational purposes only and should not be construed as legal advice for your specific situation. Real estate law varies significantly by jurisdiction, and easement rights are highly fact-specific. Before making any investment decision involving easements, consult with a licensed real estate attorney in your state who can review your specific property, title documents, and investment objectives. Every property and every easement is unique, and what I've discussed here represents general principles, not guidance tailored to your circumstances.